Judge Judy called forward Mr. Paul Doyle to hear about his complaint against his former landlord, Mr. Seidman. Mr. Doyle rented a house from Mr. Seidman from August 2015 to May 2017 with a written lease that later turned into a month-to-month lease. Mr. Seidman gave a 60-day notice to vacate in the beginning of March 2017, which Mr. Doyle complied with. After moving out, and he filed a complaint and sued Mr. Seidman for not returning his security deposit of $3,500. He won a judgment in that case, and Mr. Seidman did not return the security deposit. However, there was a suggestion that Doyle also filed a complaint and sued Seidman over the pool key. Judy wanted to know what that was about. Mr. Doyle explained that he and his family had access to 2 community pools, which they used as part of their homeschooling physical education program. After they moved into the house, they had no access to the pool because Mr. Seidman had not given them the pool key. Doyle contacted someone named Peter to help them get the key. During the tenancy, Mr. Doyle did not complain to any governmental agency about the pool key. After the tenancy, he filed a complaint against Mr. Seidman, alleging that he was in violation of some obscure statute because he did not give them access to the pool key. And he clarified that the statute had nothing to do with his special needs children, as he did not have any, and that the complaint was solely about the pool key. Judge Judy asked Mr. Doyle what the $500 stipulated judgment was for, and he explained that it was related to the pool key issue. He clarified that the stipulated judgment was for the return of the security deposit, not the pool key issue. Doyle denied the allegations and explained that the landlord had wrongfully evicted her family. The judge asked Ms. Doyle about her homeschooling and whether her husband worked outside of the home. Ms. Doyle replied that her husband worked for Homeland Security and that he worked from home 4 days a week. Judge Judy found this hard to believe and asked Ms. Doyle to explain further. She struggled to provide a clear answer, leading the judge to conclude that she was not a credible witness. Things quickly took a different turn as Judge Judy was determined to figure out who she was dealing with. The judge questioned Mr. Doyle about suing one of his neighbors in small claims court for not getting a pool key after he had moved out, which he claimed was incorrect. Judy then realized that the case was not about the security deposit, but rather a harassment case. Mr. Doyle had been counterclaimed for harassment and had filed the case himself. The judge was puzzled and wanted to know who she was dealing with. She asked questions to find out who was aggressive, who was not, who was a pain in the neck, and who used the system. She also expressed concern over the couple's homeschooling of their 3 children, as Mrs. Doyle claimed that she didn't need teaching credentials to homeschool them. Judy was surprised and said that homeschooling should be the choice of an intelligent person with teaching credentials. She also found it ridiculous that the only reason the couple wanted a pool was to get PE credit. Mr. Doyle asked how any of this was relevant to the harassment case, and the judge explained that she needed to know who she was dealing with. She wanted to find out if there were any nuts, scammers, or nudniks involved in the case. She found one nudnik on Mr. Doyle's side and said she would get to the others later. She also expressed her frustration about Mr. Doyle working from home for the Department of Homeland Security, saying that she resented paying for someone working out of their house. After some back and forth, Judge Judy concluded that Mr. Doyle was helping her while he was supposed to be working for her, and suggested that he was homeschooling his 3 children instead of working. However, Mr. Doyle denied homeschooling his children, and Mrs. Doyle clarified that she did have a plan for homeschooling. Seidman claimed that the tenant was verbally abusive and threatening. However, Judy was not satisfied with his response, so she asked Mr. Seidman's wife. She confirmed that the reason Mr. Seidman gave was not true, and he had a crazy reason to evict the tenants. The judge warned them not to play with her and that she had low tolerance for this case. Then, she asked Seidman if he had given the tenants a 60-day notice, and why he had done so. He said he did it because the tenant was overbearing and verbally abusive in their interactions as landlord-tenant. He didn't want the tenant to be his tenant anymore. But Mr. Seidman moved back into the townhome after the tenant, and the tenant moved to a house a few doors away. The tenant her evict had a judgment against Mr. Seidman for the return of his security deposit. When Judge Judy asked Mr. Seidman why he hadn't paid the tenant, he said that his house got beat up and he didn't like the court's decision. The judge found this outrageous and asked Mr. Seidman if he had appealed it, but he replied negatively. Mr. Seidman's wife tried to correct him by saying that they had appealed but were too late. But Judge Judy said too late is too late, and now Mr. Seidman had a judgment against him that he must pay.